speaker, Professor V.J. Praneshwaran, the Vice Principal of the CMR Law School, Bengaluru. And from where we have brought a lot of resource persons. In fact, for tomorrow also, we have for career mentoring, the Dr. Rishikesh. And today's, since last time we had the overview of the Muslim law, and as committed on the last date of hearing, or last session, I can say, to be precise, being a lawyer, you always tend to speak of hearing. On the previous session, we had spoken that we will take things forward under the Muslim law. And as promised, we have brought Mr. Praneshwaran on the IDDAT and DOWER, because this is two subjects which normally even a common man continues to speak, and more specifically once we watch serials and movies also, these two words do crop up. And then one feels what is the subtle difference between the two as to how it is different from the Hindu law. Without taking much time, I can always also give more insights. But once you have a good speaker, it's always better to ask him to take things forwards, and especially once we have already done the Muslim law, so that these participants can connect with that. Over to you, Mr. Praneshwaran. It is always nice connecting you off the platform and on the platform.
Thank you, Mr. Vikas Chatrat. And Vikas is just being a little generous and nice to me. So the topic selected for today's discussion is IDDAT and DOWER. The relationship, yes, there are two smaller topics. Of course, between them, DOWER is a bigger topic, and IDDAT is a smaller topic. The relationship between them is both are concerning women. Both relate to women in the sense that what one gives women and what one takes away from women. One topic, the IDDAT, it casts an obligation on the women, and of course to some extent on the man also, that is the husband also, but to a very small extent, but to a large extent on the women. DOWER, on the other hand, gives a huge right under Muslim law to the married woman and casts a huge obligation on the husband. I mean, I'll take you through that when we are discussing these two topics. Before I start off with each of the topics, I will divide each of these topics into two divisions. Of course, as I'm going through, you will not even realize I've got into the other division. What I plan to do is, first I will tell the conceptual idea or the concept of what these topics are, and thereafter the practical or the legal aspects and how it is to be interpreted. What if you have a practical issue, and how courts are interpreting, and what are the points to be kept in mind while its application in law. To begin with, both these concepts, and most of the concepts in Muslim law, are not codified. It is based on customs, and those customs accepted by the courts in India. Over a period of time, when I was dealing with the how Muslim law developed, the history and development of Muslim law in my previous session, I've told that the English Indian courts, the Anglo-Indian courts, when they applied these law, they gave their interpretation based on what was there in Quran. Thereafter, the Indian courts, which stepped into their shoes, continued to follow them and continued to interpret under the framework of our constitution. And of course, we have few legislations also which govern the application of Muslim law. But predominantly, most of the concepts which we legally perceive in Muslim law are not codified. They are based on customs, and those customs are accepted by the Indian courts, whether the Anglo-Indian courts and thereafter the Indian courts. Of course, most of these interpretations which have been accepted are from pre-independence Anglo-Indian courts, thereafter continued under the constitutional setup, because these decisions and these findings of the courts, especially Allahabad High Court, Lahore High Court, Calcutta High Court, Patna High Court, and Madras High Court. These are roughly about 5 or 6 high courts which have contributed extensively. Of course, we have Privy Council and the House of Lords also, but not much. But then these high courts have contributed enough with regard to crystallizing the concepts. Now, iddat, going into iddat in Arabic simply means counting. Now, what is to be counted, and what is this concept for? Iddat, the concept iddat, which means counting, was introduced in Quran and during those times to ascertain the possible conception, that is to see whether the wife has conceived, and to fix paternity, in the sense that not during marriage, of course, on the dissolution of marriage. Once marriage dissolves, the concept of iddat arises once marriage has dissolved, to understand whether the woman has conceived. And the question arises, what is the reasoning behind understanding whether a woman has conceived or not after the dissolution of marriage? That is to fix paternity, to ascertain paternity. That is why this concept is there. And from the point of view of law, the importance of iddat is maintenance. Whether the woman is entitled to claim maintenance, iddat is an important aspect under Muslim law. The Muslim woman is entitled to maintenance only up to her period of iddat. Now, what it means, how dissolution happens, and what are the periods specified. Dissolution of marriage can be of two types. One, dissolution of marriage by divorce, and dissolution of marriage by death of the husband. If the marriage has dissolved by divorce, whatever be the form of divorce, irrespective of the form of divorce, then after divorce, the woman is expected to observe a period of iddat. That is a certain period. And what is, I will tell you. She is expected to remain in seclusion, not to mingle with anyone, and so that there is the chance of she mingling, or there is the chance of any doubt of any other man coming in contact with her is ruled out, and that will ascertain the paternity in case she has conceived during that last period of the dissolution of her marriage with her husband. Now, in case of a divorce, and if the marriage has been consummated, then the period that the woman is expected to follow is 3 months. It can be taken as 3 lunar months also, because Islam follows lunar calendar. But usually it is 3 months. If the marriage has not been consummated, then the woman need not observe iddat. Continuing with that, during this 3 months, when the marriage is dissolved because of divorce, and say for example marriage, there is a divorce, she is observing iddat, and after 1 month she is found to be pregnant, then the period of iddat continues till the childbirth or abortion. So once pregnancy is confirmed during iddat, the period of iddat will continue till her childbirth. Now, secondly, this is with regard to marriage dissolving by divorce, by the act of parties. In case marriage dissolves by death of the husband, if the husband dies, then the period of iddat to be followed or to be observed by the Muslim woman is 4 months and 10 days. And this applies whether the marriage has been consummated or not. And thereafter, especially in case of death, when marriage dissolves by death, if she is pregnant, she could be pregnant even before the husband's death. She is already pregnant and the husband dies, or the husband dies, she is observing iddat and she is found to be pregnant, then the period of iddat continues till the childbirth or abortion, as the case may be, or 4 months and 10 days, whichever is longer. Now, say if the woman is into the 7th month of pregnancy and thereafter the husband dies, and then she needs to observe iddat of 4 months and 10 days, because even though by about 2 months, 2.5 months, she after the death of the husband, she will deliver a child. Nevertheless, it is either childbirth or abortion or the period of 4 months and 10 days, whichever is longer. Now, this in case if the husband dies during divorce iddat. Going back to that is a woman observing iddat on divorce. Say the woman divorces, or the husband and wife they divorce, and the woman is observing iddat. During the period of iddat, of course, marriage is dissolved, the husband dies. Then the woman needs to observe what is known as death iddat. That is iddat to be observed after the death of the husband, that is 4 months and 10 days. And the point to be noted here is the period will start afresh. I'm giving a very extreme situation. Say there's a divorce between husband and wife, a Muslim husband and wife, and she's been observing a divorce iddat of 3 months, and it is 2 months and 29 days. On the 29th day, if the husband dies, then she needs to start her death iddat afresh of 4 months and 10 days from that. So the period spent is not counted. So this is a small topic and about iddat. Then, what are the legal aspects about iddat? One, the Muslim woman is entitled to maintenance up to her period of iddat. Now, whether it is a divorce iddat or a death iddat, or she continues to her iddat because of she is found pregnant, or there is a divorce iddat and it is extended because of death of the husband during iddat. In all these scenarios, all that is required is she is in her iddat period, whatever be the reason. She is entitled to maintenance. Contrary, after iddat, she is not entitled to maintenance. Of course, this concept of not entitled to maintenance and maintenance is a totally another topic. But however, she is entitled to maintenance only up to her period of iddat. This is one legal implication of iddat. Secondly, during the period of iddat, the woman cannot remarry, irrespective of the kind of iddat, whether death or divorce and subsequently death. When she is observing iddat, the woman cannot remarry. Then the question arises, what if she does? If the woman is a Sunni, then the marriage is irregular. Under Muslim law, you have three classifications: a valid marriage, a void marriage. A void marriage is where there is no marriage, and there is also what is known as irregular marriage, an irregular marriage. There are certain instances or certain qualifications or prescriptions which if they are not fulfilled, then the marriage is irregular. Once this irregularity is removed, then the marriage becomes valid. So if a woman is observing iddat and she remarries, then the marriage is irregular. Now, the marriage will become regular on the expiry of the period of iddat. This is applicable to Sunnis. In case of Shias, the marriage is void. So there is no question of a period after the period marriage becoming regular. Straight away, according to Shia law, the marriage during iddat is void. Then the question arises, when the period of reckoning, that is the commencement, whether it is from the date of death or divorce, or whether it is date of knowledge. Now, this situation arises because under Muslim law, a husband can divorce his wife without the presence of the wife, without the wife even knowing. All he has to do is there must be a pronouncement. Of course, now triple talaq is not valid, but there is the other kind of talaq where 3 times talaq is to be pronounced at 3 different intervals of a month each. The triple talaq, the commonly known, what we know as triple talaq, is pronounced in a single breath, that is one after the other immediately. That is not there now on the law books. But then the most proper form of talaq is there, where you make one pronouncement once, thereafter you make the second pronouncement after 1 month, then you make a third pronouncement after 1 more month. So it takes a 2-month period. Until you make the third pronouncement, it is the marriage does not dissolve, and you can always recall it by either by your conduct or by your by expressly or impliedly. But this pronouncement need not be made in the presence of the wife. The wife need not even know. So the question arises, if the wife does not know that she has been divorced, then death of the husband, if he has, again, this is to be seen from the perspective of the situation that was in Arab when Islam originated. There were continuous war. People used to go on a voyage and expeditions for either war or business. You did not hear about your husband for a very long time until he came back. So the question arises, from when the period of iddat commences? Like in our limitation, we start, when does the limitation start running? For example, if it is a cause of action, from the date of cause of action or from the date of knowledge of cause of action. But however, for iddat to start running, it is not from the date of knowledge, it is from the actual date of death or divorce. That is to say, if the husband has divorced his wife without her knowledge in her absence, and by the time she gets to know, if this 3 months has elapsed, then she need not observe iddat. So that's the interpretation. So the commencement of the period of iddat is from the actual date of death or divorce and not from the date of knowledge of the wife. Then among Shias, there is a small difference in interpretation. In case the wife has not attained puberty, in case the wife has attained menopause, that is beyond the childbearing age, then iddat is not required. So this completes iddat, a small topic, what is to be followed, what the woman. So this does cast an obligation on the Muslim wife to observe a certain prescribed method after divorce, so that the conception is confirmed and then paternity is affixed. Now the question arises, the woman is prohibited from marrying during iddat. What about the man? Whether the husband, or what does the law say, or what is the interpretation? Now the man or the husband, the erstwhile husband, need not remain unmarried during the period of iddat, in the sense that he can marry during the period of his wife's iddat, because there is no question of man observing iddat. So during his wife's iddat, a man can marry. However, there is one exceptional situation, very exceptional, in the sense that in case the man had 4 wives, again, a little bit of Muslim law on marriage. Under the Muslim law as applied in India, a Muslim man can have 4 wives. It's perfectly valid. In case the Muslim man has 4 wives and he divorces one of them and she is observing iddat, then there is a small restriction on the erstwhile husband's right to remarry. He cannot remarry. If he remarries, the marriage is irregular and it will become valid only upon the irregularity being removed, that is when the wife completes her iddat period. So that's all about iddat, a small topic, but then nevertheless very important. Of course, iddat per se appears to be small and irrelevant, but then when this concept of iddat is combined with the concept of maintenance, again, maintenance is another huge topic altogether, maybe sometime later, then it becomes very relevant. Iddat, for two reasons, is very important. One, to ascertain paternity. Second, to fix responsibility on the husband or to make the husband liable to pay maintenance. So that is iddat. Then we come to dower. What is dower? Of course, very sometimes dower is equated with a dowry. It is not exactly dowry. You should understand the concept. And then the other name for dower is meher. It is interchangeably used. Meher was used in pre-Arab time, pre-Islamic Arab. And now thereafter it is called as dower. Prophet changed the concept. To understand dower, what is that concept? We need to go back to Arab during the advent of Islam or prior to Islam. Prior to Islam, the practices with regard to marriage or with regard to taking a woman was a couple of practices, not all of them. I'm not listing all of them. A couple of practices. Either the man approaches the guardian of the woman, pays him some money, that the man pays money to the guardian and takes the woman as his wife, or the man directly approaches the woman, pays money to her, and takes her as his wife. Now, this was the arrangement prior to Islam, and this concept after advent of Islam, Prophet Muhammad thought of retaining this payment, but then he changed the idea or the concept about this payment. Earlier, prior to Islam, this was more like a bride price. That is, you pay and take your bride, kind of buying your bride. The second aspect about this payment prior to Islam was that the money could be paid to the guardian also. But once Prophet Muhammad came into existence and his teachings and preachings, he made a slight change. He changed the concept, totally changed the concept of dower, and he made it more like an amount paid to the woman as a mark of respect to her. This is the distinguishing feature. Dower is consideration paid to the Muslim married woman by her husband as a mark of respect, and it is to be paid to the woman and not to the guardian. These are the changes that Prophet brought about with regard to the payment. And of course, there are a couple of other interpretations earlier that it could be bride price. That is one interpretation. The second interpretation is it is a consideration for contract. Again, if we go back and consider the nature of Muslim marriage, one of the arguments is Muslim marriage is in the nature of a contract, a civil contract, and dower becomes the consideration. This view is not held to be correct. It is not consideration for contract, because in a contract, if consideration is not there or if it is not fixed, the contract does not go through. However, you will know when I go to explaining the different kinds of dower and the various aspects of dower, that even if dower is not fixed, it is assumed that dower is always present. So there cannot be a Muslim marriage without dower. If no dower is fixed or nothing is spoken about a dower, then even then there is a presumption that dower is always there and the husband is always liable to pay dower. So conceptually, dower is considered to be consideration paid to a woman as a mark of respect to the woman in connection with marriage. And it imposes a huge obligation on the husband the law imposes a huge obligation. The husband is liable. The right is never lost. Again, that we will see later. Let us try, but we'll first try to understand what is dower. So, the meaning of dower is it is a consideration paid to the woman as a mark of respect in connection with her marriage. The kinds of dower. What are the different kinds of dower or the classification of dower? There are two kinds basically. One is the specified dower, and the other is the unspecified dower. And then as the name suggests, in specified dower, a certain amount is fixed, and in unspecified dower, the amount is not fixed. Now, a little bit deviating into the practical aspect, how it exactly happens is at the time of negotiation, if it is a specified dower, they negotiate or they fix a price. Actual price is fixed in terms of consideration. Of course, what can be fixed, we'll deal with it later. But then it is fixed prior to marriage. The consideration for the marriage being dower is fixed. That is specified dower. That is a certain quantity or what is to be dower is fixed. So that is specified dower. If nothing is spoken about dower, then it is called as unspecified dower. Then specified dower is again classified depending on when payment becomes due as prompt dower and deferred dower. Whereas in unspecified, it is always there's only one kind, unspecified, but then there are a couple of other names. Unspecified dower is also known as proper dower or customary dower. Now, we will finish off with the unspecified dower because that is a smaller topic compared to the specified dower. An unspecified dower is a dower which, in the sense that it has not been fixed at the time of marriage. Now, I had told earlier that dower is an integral part of a Muslim marriage. Even if it is not specified, even if nothing is spoken about dower, even if it is told that I will not pay dower, even then dower is always there and law will recognize it. Even if there is a contract to the contrary, that is a pre-marriage contract. In Muslim law, pre-marriage contracts are allowed, provided they are not un-Islamic. Even if there is a pre-marriage contract stating that, yes, I will marry, the husband says, but then you should not ask dower, and the prospective wife says, yes, I will get married to you, or you can get married to me, but then I will not ask for dower. Even if there is a contract, once there is a marriage, once a marriage goes through, dower comes back, in spite, or rather notwithstanding the contract to the contrary. So under any given circumstances, if there is a Muslim marriage, there is always a dower, whether it is specified or unspecified. Specified, parties have accepted, fixed the quantum, fixed the kind, everything, fine. If nothing is spoken about, conveniently silent, or even if there is an intention to the contrary, dower is always there. It is never lost. It always is present in a Muslim marriage. Then in a unspecified dower, then comes the interpretation of how to fix it. This is very interesting. One, under the Sunni law, again in my previous lecture, I had told that when we were talking about the schools of Muslim law, the Shia school and the Sunni school, and what is the difference between them, the application of law. Wherever there is difference, it will be specified. So here, when we are dealing with these topics, here we come across the differences in the interpretation of law and the application of law between Shia and Sunni. Under the Sunni law, if it is an unspecified dower, then the court will fix what is to be paid actually. Now, dower is always there in a Muslim marriage. I keep repeating because it is very important. Even if there is a contract to the contrary, that contract is void with respect to that aspect of dower not being there, because it is considered un-Islamic in the eyes of, in the words of Prophet, that dower has to be there as a mark of respect for the married woman. So in the case of an unspecified dower, the question arises how to fix the quantum. What is to be fixed as quantum? Then courts come into picture. The courts, you'll have to approach the court to fix the quantum, and court will fix the quantum. Then a follow-up question is, on what basis? Here is the interesting factor, and here is where a slight difference between other interpretations and other laws, specifically other personal laws. Usually, when an obligation is cast upon the husband or the erstwhile husband, and if the quantum is not fixed, then one of the primary and very significant factor that the court will take into consideration is the capacity of the husband and the capability of the husband. This is in other personal law jurisprudence. But however, in Islam, it's totally different. It is actually contradicting. I mean, in the sense that it is totally opposite, not contradicting. It is totally opposite. Fixing of dower in an unspecified dower has nothing to do with husband's capacity or capability. Whether you have capacity or not, whether you have capability or not, you still have to pay dower. That is the first premise. Second, you still have to pay it, whatever has been fixed by the court. Now, the husband cannot throw up a defense that I don't have salary, I don't have a source of income, this is not my capacity, this is not my status. No. So the fixing of an unspecified dower depends not on the husband's status, on the contrary, on the wife's status. And there are other considerations also. The first consideration that the court will look into, again, the court's interpretation is based on what is there in custom and what has been accepted, the custom that is there in Islam, as mentioned in Quran, and thereafter the other sources, and as accepted by the Indian courts. The first aspect is personal qualifications of wife. Now, when I say personal qualification, I'm not talking about only educational qualification. That is why the adjective personal is used. Personal qualifications. It makes a wonderful reading what all are considered. First, very important, the beauty of the wife. Second, the fortune of the wife, in the sense that what is her status. Third, understanding of the wife. Now here understanding means probably we can interpret it as her education or her knowledge, worldly knowledge. So in today's world, we can interpret it as education. And fourth, even more interesting, virtue of the wife. So when we are talking about personal qualifications of the wife, we are talking about what are the different aspects is: one, beauty; second, fortune; third, the understanding, that is the education, qualification, and her understanding or her experience also. Not, see, when I'm telling education, not necessarily strictly orthodox and education in the terms of degrees that we have, like an LLB degree or a BA degree or an MBBS degree. Not necessarily that. It could be a practical qualification also. It could be an experience. She could be a very experienced midwife and earning a good salary amount of money. So it could be anything, qualification or education. And fourth is virtue. I will not go deep into what is virtue. It is no. Second aspect that the courts will take into consideration is the social position of girl's father and his family. Now, why social position is, what was the dower fixed in the father's family of his female relatives? For example, starting from the father's sister, father's other daughters, that is this girl's sisters or half sisters, the girl's cousins on the father's side. What was the dower fixed in their marriages? That will be taken into consideration. And thirdly, the custom or the dower paid in wife's paternal family. That I already, that is, what did they actually pay? So the status and social position of the girl's father and the custom or the dower paid in the wife's paternal family. For example, what was the dower fixed in her sister's marriage or in her cousin's marriage or in her aunt's marriage on the father's side? These things will be considered. Two important exclusions: mother's side will not be taken into consideration. That is, the girl's mother's side and their status and their custom will not be taken into consideration. And like I said, the second exception, very important from a legal perspective that we all know have to know, is husband's status is not considered at all. Neither the husband's status, nor his paying capacity, nor his earning capacity is taken into consideration while fixing this unspecified dower. This, what I told till now, applies to Sunnis, the Sunni Muslim. Now, to Shias, it's a little different. In fact, a lot different. If the woman is or if the parties belong to Shia Muslim, then it is very simple and easy in fixing unspecified dower. The unspecified dower fixed under Shia law is 500 dirhams. Now, dirham is the currency that was followed then. I think now also we have Middle East, some of the countries or a couple of countries have a dirham as their currency. 500 dirhams is considered to be the unspecified dower that is to be fixed. So if you are a Shia and if there is unspecified dower, you don't have to go to the court. It's already fixed, 500 dirhams. Dirham, practically converting, either you can do it two ways. Dirham was a silver coin. See, when we're talking about 500 dirhams, this dirham is conceptually taken from when Islam advented in the Middle East. So it was a silver coin, roughly about, I think, maybe about 3 grams or something. Now, of course, dirham, you have currency notes. So two interpretation, either the value of that silver 3 grams, you convert that is very convenient, or today's dirham's value, you do it. That is open to interpretation, and courts have not crystallized that. Why 500 dirhams is because it is told that it is the tradition of the Prophet, in the sense that Prophet followed that. Why? In Fatima's marriage, again, if you recollect, Fatima is Prophet's daughter from his first wife. In her marriage, when she was given in marriage to Ali, 500 dirhams was fixed as the as the dower, and that is followed by Shias, because Shias strictly follow tradition of Prophet. That is another difference between Sunnis and Shias. Shias, in terms of interpretation of law, a little orthodox as compared to Sunnis. So 500 dirhams will be the unspecified dower in case you are a Shia Muslim. Now comes the specified dower, when dower is actually fixed. Now, dower are fixed by the parties. Of course, practically when it happens, both the families sit and they discuss and fix, but then law presumes that the parties, the actual party, that is the boy who's going to get married, and or the man who's going to get married, and the woman who's going to get married will fix it. So the parties fix it. In case the parties to the marriage are minors, here again question comes whether a minor can be married. Yes, under Muslim law, the rules of marriage are a lot different. Majority, for the purpose of marriage in Muslim law, is not 18. It is age of puberty, generally accepted as 15 years, subject to contrary proof. For example, if you're able to show that the person is attaining puberty prior to 15, then the person becomes valid for a marriage, or subsequent to 15. But generally accepted age is 15 years. So it is open to rebuttal. So in case marriage of a minor, so when I'm using the term minor in Muslim law connected with marriage, it is age of puberty generally accepted as 15 years and not 18 years. In case of minor getting married, then the guardian fixes the dower. And under Sunni law, though the guardian fixes the dower, it is binding on the boy or man once he attains majority. On the contrary, under Shia law, the guardian is liable, it's not the boy. This is a small difference with regard to fixing. So specified dower is actually fixed by the parties prior to marriage, and they go ahead after fixing. Then the question arises, what can be dower? What can be fixed as dower? I did talk about it in terms of consideration, but I also mentioned that it could be anything of value, it could be anything that could be quantified, and most important, it should not be un-Islamic. Usually it is property of some kind that is fixed as dower. However, there are a couple of interpretations where, though something which is not capable of being valued in terms of monetary consideration, it could still be dower. That we will see later. Otherwise, property of any kind, tangible, intangible, mobile, immobile, any property could be fixed as dower. Again, coming to practical aspect, how usually it is done, and some amount of money is fixed usually, but not necessarily. It can be anything. For example, I'll give you a couple of examples of what can be fixed as, what can be fixed as dower. It could be a flat. Say the husband promises that, okay, I'll buy you a flat of a particular area, or I'll buy you a car, or buy you a site, or this is the amount. Usually in today's practices, generally money is fixed as dower. However, one practice has inadvertently crept in. Here I'm going into a little bit into Muslim aspects of religion, and it is also connected with law. That when fixing of dower, neither a fancy figure should be fixed. When I say fancy figure, which is much beyond the reach of the husband or the wife herself, it should, contrarily, the dower must be fixed keeping in mind the status of the woman. It should neither be fancy too high, or it should neither be very less. Unfortunately, I've come across a couple of instances where a nominal amount has been fixed as dower. That is wrong, both under law and under the Islamic religion as such, because it has to be fixed keeping in mind the status of the woman and going by the objective of why it is fixed. So property of any kind can be fixed. Quantity in commensurate with the woman's status must be fixed. Now there are a couple of other interpretations which says that something apart from property, which though does not have monetary value, but then it is of value in Islam, can be fixed as dower. There is one reference in Fatwa-e-Alamgiri, that is a book written by Aurangzeb, wherein, and that has been accepted by one of the jurists, modern day jurists, Amir Ali, which finds mention in the books on Muhammad Islam, that is Muslim law. Even Mullah's principles mention that. That is rendering of Quran. What do you mean by rendering of Quran? See, again, now to understand this, I think we should deviate a little bit and go into religion. Now, rendering, or if you recollect, what do you mean by Quran? When I said in the last lecture, it is Quran means the reading. That is the one that something should be read. It is a postulate under Islam that every Muslim must read Quran. And if you read Quran, that is one of the ways of attaining, or one of the ways of following God. So, and this, either you do it yourself or somebody else can do it for you. So if somebody else does it for you, then also you get those benefits. That's the understanding. So the husband can say that on your behalf, I will read Quran. So that is called rendering of Quran by husband on behalf of the wife. And this is one thing which is in modern times in terms of consideration, monetary value. This sounds or this appears to be of no value, but then under religion, this has a lot of value. Secondly, somewhere in between, what is known as personal service. The husband can say that I will render some personal service to you, to the woman, which shall be dower. Now, on a lighter note, I can give you examples of personal service, like the husband says that, okay, fine, I will wash your clothes for 6 months, or I will wash your clothes forever. That could be a personal service. Or it could be giving her some amount of money periodically, or promising her that every weekend he will take her to movie, or promising her that every alternate day he will take her to her parents' house. So again, this is open to interpretation, but this could be some of the few examples of what could be personal service. This again, there is a difference between Shia law and Sunni law. Personal service is accepted under Shia law, but in Sunni law, personal service is not accepted as a valid dower. Then dower once fixed can be changed. However, it can be changed in the sense that it can be changed to benefit the wife and not to her detriment. In put in simple sentences, dower can be increased but not decreased. This can happen after this will happen only after marriage. And after marriage, the parties to the marriage can enter into a contract wherein they change the quantity of dower, where the dower can be increased but never decreased. Again, the interpretation, even if there is a contract after marriage wherein the wife has admitted to either decreasing the dower or even telling that I will not ask for dower, the contract is void and dower still remains as it is, fixed in a specified dower. So this is specified dower generally. Then the two kinds of dower, that is prompt dower and deferred dower. In dower, in unspecified dower, the question of payment arises only on the dissolution of marriage because it is unspecified, either by death or by dissolution of by divorce. Whereas if it is a specified dower, it could be otherwise also. That is why we are calling it as prompt or deferred dower, two kinds. In prompt dower, when the dower is specified and prompt, what it means is prompt. By the name, as the name suggests, prompt means immediate. If the parties accept that it will be a specified dower, they fix a price, they fix a consideration, they fix an amount, and they also agree that it will be prompt, then what it means is immediately after marriage, the right to dower becomes vested in the women. And we know what is a vested right. That is, she is entitled to it. All that she has to do is ask, of course, and we use the term demand in law. So in a prompt dower, immediately after marriage, the moment both of them say kubul, 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 then the dower becomes a vested right in the woman, and all that she has to ask is, all that she has to do is demand, and she can demand it immediately after marriage. Perfectly fine. Now, when she does that immediately, the question whether marriage has been consummated or not is not relevant. That means even if the marriage has not been consummated, the wife can still demand her prompt dower. And not only that, if it is a prompt dower, and she has made a demand, whether immediately after marriage or sometime later, and the husband makes a delay in payment, she is entitled to interest. And very interesting and most important, the woman can actually refuse consummation unless the man pays the dower. So immediately after marriage, the woman can say, boss, you give me my dower, everything else we can see later. And it's perfectly valid. So this is prompt dower. Prompt dower is liable to be paid or is vested immediately on the marriage and can be demanded anytime. Once there is a demand, the husband is liable to pay. It does not depend on anything else. Coming to deferred dower again could be either on the dissolution of marriage or on the happening of an event or after a particular amount of time. This is again fixed by the parties. When it is a specified deferred dower, the parties will fix, okay, on the birth of the first child, on the birth of the first son, or if the husband contracts a second marriage. These are the threshold dates or the relevant dates which could be fixed. Or if the husband gets a job opportunity outside the place where they are usually staying. So time, it is either on the happening of an event or a specified time could be fixed, or they can simply say on dissolution of marriage. The difference between deferred dower under specified dower and unspecified dower is, in unspecified dower, parties don't agree, but even if they don't not agreeing, the payment becomes due on the dissolution of marriage. Whereas in deferred dower, they agree that the payment will become due on the dissolution of marriage. And if it is unclear whether, see, because when you usually enter into a contract, mostly it is oral contract, sometimes it is reduced into writing. Even if it is reduced in writing, if the recitals are not clear, if it is not clear whether it is prompt or deferred, then under Sunni law, it is partly prompt and partly deferred. And what part is partly prompt and what is partly deferred will be decided by the court, interpretation of the court. Whereas in Shia law, if it is unclear whether it is prompt dower or deferred dower, it is always interpreted as prompt dower. Then the liability of the husband arises. Here, now we are into the practical aspects. Once wife demands what husband needs to pay. Now, what amount of the dower, whether it is specified or unspecified, that the husband needs to pay, depends on whether marriage has been consummated or not. If it is a valid marriage and if the marriage has been consummated, then the husband is liable to pay full amount or whatever has been specified or whatever has been fixed by the court or by the parties as dower. If the marriage is valid and if the marriage has not been consummated, then the husband is liable to pay half the amount of dower. Then the second instance is if it is an irregular marriage. If it is an irregular marriage, then if the marriage has been consummated, then it is specified dower or proper dower, whichever is less. Specified dower is what has been agreed by the parties. Proper dower is what is fixed by the court, that is unspecified dower. So if it is an irregular marriage and the marriage has been consummated, then the lesser of specified dower or unspecified dower. Then in an irregular marriage, if the marriage has not been consummated, then the husband is not liable to pay any amount. I think we are almost reaching time. I'll just run through just a few legal aspects, how it is to be interpreted and what happens under different circumstances. After marriage, once the dower becomes payable, the wife can remit, in the sense that she can either reduce or give up her right. This has to be voluntary. Now, the difference, I told that the amount of dower cannot be reduced by a contract. That is between both the parties. Here, what we mean is the wife on her own volition voluntarily remit the amount. It is called remission of dower. Now here the remission, the concept of remission as understood under Islam is the wife is gifting her husband. It is like husband, say for example, if 1 lakh rupees is fixed as dower, it is like husband giving the amount of 1 lakh to the wife as dower, and the wife immediately giving back that 1 lakh as gift to the husband. That's the understanding. So there can be a valid remission provided it is voluntary. Okay. Then characteristics of dower in terms of law. What are the attributes of dower? Once there is a Muslim marriage, dower arises, and once there is a right of dower, it is never lost under any circumstances. Even if the woman is of loose morals, even if the woman converts to another religion, that is apostasy. Apostasy does not lose dower. That is, the woman does not lose a right of dower even on apostasy. That is, if she converts to another religion, it is still not lost. And secondly, the courts will recognize a woman's right to dower as an unsecured debt. Okay, so it is, the right is never lost, and it is like an unsecured debt. How do you enforce it? The woman asks, the husband does not pay. How do you enforce it? One of the usual ways, we all know how women get things from men. Refusal of conjugal rights. Of course, that is, I'm telling on a lighter note, but nevertheless, that is her right to refuse conjugal rights is recognized in the sense that when a wife refuses conjugal rights because her dower has not been paid, then she has a valid right to stay away from the husband, go away from the husband's house, and the courts cannot issue any order against her for restitution of conjugal rights. So when dower remains unpaid, she has a right to refuse conjugal rights. Second, the wife can enforce the debt as enforce dower as a debt. It's an unsecured debt. She can file a civil suit. And thirdly, again, this is very peculiar to Islam, what is known as right of retention. Of course, right of retention, both wife and widow, mostly widow. If she is in occupation of a husband's property, she can retain possession. Of course, rules are applicable that in the sense that the possession of that property must be voluntary during the lifetime of the husband. Then she can retain possession until her right to dower is satisfied, either by the husband on dissolution, or if the husband has died, then it is liable on the estate of the husband. And the right of retention is a possessory right. That is, she can only possess, she cannot convey it to anyone. It is not transferable in the sense that because it is a possessory right, it has been interpreted to be a personal right. It is connected with her person, and hence she cannot transfer it to anyone. However, the third attribute of the right of retention of a widow's right to retain her husband's properties in lieu of dower is it is heritable, in the sense that if she dies, she has a right to dower, it remains unpaid, and she's retaining the property, and she dies, then that right is heritable by her legal heirs. So this is all I intended to speak about dower and IDDAT. I'm open to questions. Oh my God.
Yeah, we have this session was extremely good, and I am seeing a few of our regular followers are also watching on the Facebook. And this is by Dr. Shrikant. Does Islam permit transfer of right to dower to a third party on consent from third parties?
No, dower cannot be transferred. It is her personal right. That's what I said. It cannot be transferred. It is her personal right. It cannot be transferred to a third party. Of course, it is heritable on the on her death, it is either the estate of the husband's, if the husband has died, his estate is liable, or if he is alive, then inherited by her legal heirs.
This is by Dr. Shrikant again. What is generally considered as Islamic finance mediated exercises?
Please come again. Islamic
finance mediated exercises.
I'm not sure what he means actually by finance budgeted exercises. Probably, I presume that in connection with the dower, how it is to be fixed. It is fixed in terms of that, like I said, it is fixed in terms of the status of the woman. This is a marked difference between other personal laws where status of the husband, when the liability arises, the husband's status is taken into consideration or his earning capacity. Whereas here, irrespective of who you are, it says that according to the status of the woman, you need to marry. I mean, you need to pay the dower.
So yeah, we can ask, and in the question, I don't think, but we have got any.
Transfer of right to third. What is generally called Islamic finance mediated?
No, that question I've already read.
Yes.
Yeah.
No, I'm just seeing whether I've understood the question right.
No. Dr. Shrikant wants to ask a question himself directly. Just unmute him. He's also from Bengaluru.
Oh my God, he's my good friend. I think he's.
Namaskara, sir. Hegidira?
Hey, namaskara, Shrikant. Chanagidira. Again, Beyond is helping us connect.
Shrikant normally doesn't want to come on the Facebook. No, on the with his picture.
Yes, Shrikant.
I can only say parda uthao.
Sorry, cut agittu. What I wanted to ask you was, especially when there are multiple wives, and then when you have 3 wives and 3 dowers are there, is there a precedence for the dower to be taken, especially when it is a prolongated or a obligated dower, which occupies for the entirety of the marriage? That is the first question which I wanted to ask. Second question is with respect to the mediation exercise, does Islam provide that this dower settlement should be mediated first? Is it there in, because generally Islam provides for mediation as a first opportunity of settlement of disputes. So is dower dispute also mediatable? Is a question.
Okay, I'll answer your first one by one. Yes, I've understood that question. The first question is with regard to if he has multiple wives. Now, to answer that question, I have to get out of dower and understand the concept of polygamy under Islam. See, what Quran says is, Quran never says that you shall marry 4. Quran actually says that have one and take care of her properly. But what also Quran says is, if you want, you can have 1, 2, 3 or 4. Now, why 4 is because it is said that it is the tradition of the Prophet. Okay. Now, Quran also says that if you are marrying more than one wife, it is the obligation of the man that he looks after each one of them equally, both in terms of love and providing for them. That is, providing them the facilities. And Islam also says that if you are not able to treat your wives equally, don't go for the second one. On the contrary, if you don't treat your wives equally, then you don't go for polygamy, or it is un-Islamic. Now, coming back to your question of fixing of dower and having 3, 4 wives. Again, it's just, if you don't have the capacity to pay dower, that is why this is the concept why Prophet introduced dower, giving a safety to the woman. Otherwise, what happens earlier, what used to happen is some small amount, whatever amount was paid to the guardian, nothing to the woman, married and suddenly left. So there were too many women unattended and uncared for. So to take care of that. So if you think you don't have the capacity, don't. But if you are going for plurality, that is, if you're going for polygamy, the understanding and interpretation is you have the capacity. even if you don't have the capacity, because you have gone for a polygamy, because Quran says that if you do not have sufficient means, don't go for more wives, and if you go for more wives, you should treat them equally. The presumption is you have to pay for them. That is answering your first question. Second question, Srikanth, I think it is regard to Srikanth, what was the second question? I just forgot. Maybe I should have made a note.
Meanwhile, there's one question by Abhishek. Is there any limitation to file suit for recovery of dower?
See, I said dower is like an unsecured debt. Then limitation 3 years, same thing will apply. Again, the interpretation here would be from when does it start running? So when does the cause of action arises? From the date of demand, continuous demand, all that will come under civil laws of interpretation of when that it is considered as a unsecured debt.
Then Mansoor, if man wants a divorce, what are the court procedures?
For a man, again, we are going into divorce, marriage and divorce. Nevertheless, I will answer. For the man, a Muslim man need not go to the court. Doesn't have to go to the court to, and even if he goes to the court, he cannot get divorce. He has to do it on his own. This is something like you have it with yourself. Why would you want to go to the court? You can go for talaq, the most proper talaq, the revocable talaq, or khula or mubarak. You don't have to. Man doesn't have to go to the court. But if a woman wants, between them, khula and mubarak is available. But if the man refuses, then grounds of for Muslim women on divorce. That is, there is a in 1939 there was a law enacted giving the grounds for divorce. She has to fight for divorce. Srikanth, can you tell your second question? Also very interesting. I had that registered in my mind, but then when I was answering the first question, I lost.
I don't know Srikanth is there or not.
He was
I'll just check it out. Meanwhile, take this question of Edison. I will meanwhile check it out.
Yes. Yes, I think I got the question. I think this Edison's question is very second question related to Srikanth's second question, Edison's question. What Srikanth was asking was, will there be a mediation? See, when parties are in conflict only, they'll go to the court. There is a saying in Urdu, Miyan Bibi Razi, to kya karega kazi. That means when the husband and wife have agreed, what can the court or the judge do? In the sense that when the dower becomes payable, let's presume it is unspecified dower and you have to go to the court to fix it. Now you will go to the court only because you have a dispute and you are not fixing it or able to fix it on your own. But if you are sitting for a mediation and if you are able to come to a conclusion of certain amount, if the parties agree, the courts will simply agree to it. The courts cannot override it and go against what has been accepted by the parties. So Jamaat, again, who will intervene is ultimately we are looking at whether parties are agreeing. Now, under whose intervention, we are not concerned. The law is also not concerned, whether it is by mediation or whether it is by mediation by whom, whether it is a court-appointed mediation or within the religion, the Jamaat, doesn't make a difference as long as they are agreeing. Miyan Bibi Razi to kya karega kazi. The next question I see, he was a rich when he has 4 wives, but after years he can't pay on his death due. All who gets now, if his estate does not have and he dies, what can we do? Nothing can be done. Again, the interpretation is open whether there will be a rateable distribution or well, it will be a first come first serve. That's open to interpretation. However, if nothing is there and he dies and he does not have an estate, then if you apply equity, because a lot of places in Muslim law, equity is applied. If you apply equity, then all 4 wives should get a rateable distribution. This is again, this has not come up, this is open to, again, this will differ whether it is Shia law or Sunni law, because there is another aspect where in terms of will, in Sunni, they apply rateable distribution. In Shias, they apply first come, first serve. So open to the courts to interpret. Still, nothing has come out If Abhishek again, if
Woman's dower is not accepted, she could refuse marriage.
See, again, we'll have to go by this ceremony. Unless here in Muslim marriage, unless the woman says yes, there is no marriage. It is like a contract, often an acceptance. Okay, so if she has not got, or if she is not accepting to the amount, and she can very well say no, but if she is not accepting to the dower and she says yes, marriage will go through, dower will be fixed by unspecified dower.
Yeah. So, Mr. Praneshwaran, I don't think we have any other questions.
One
Two
more,
questions by Rita has been posted. I have not been able to understand.
This again, pension for wives. This is not dependent on Muslim law. This is dependent on civil law. This is because in marriage for wives. If you are a government servant, you have to take permission from the government to marry a second wife. Leave for. So then the pension rules as applicable and mention will be made in the respective pension rules of who gets it and how they get it. This has nothing to do with Islam.
Yeah. Yes. So yes. So that's for today. And friends, as usual, today's session also was very precise and concise. And what we had requested him also, that we should have the bird eye view, but the bird eye view has shown much more than what we could have imagined. And Dr. Sirikant probably has had to leave. He's quite a busy person as a lawyer as well as he has to attend a lot of webinars plus give his own insights. So tomorrow the session would be on mentoring and career growth tips. As we all say that we all take sessions on law, plus we also take some soft skills and also beyond law as the topics itself suggest. So do stay connected with us. Tomorrow it will be MP Rishikesh, Director HR, CMR School of Law, Karnataka. Again from same school of thoughts as well as same school from where Mr. V.G. Praneshwaran has come. He's the vice principal out there. So do stay connected with us tomorrow at 4:30 p.m. Everyone stay safe, stay blessed. And Mr. Praneshwaran, thank you. And thank you to all those participants who have been watching us live on the Facebook, YouTube, as well as on this platform. Everyone stay safe, stay blessed. Jai Hind.